My lords, we had circulated a note, my lords, last week and 3 compilations. And we have, my lords, circulated 1 additional compilation yesterday, my lords, yesterday evening. Additionally, my lords, I will also be referring to note 2 of the learned SG, my lords, because the aspect with regard to child.
Yes.
And my lords, at the outset, I must also say, my lords, that though the application is filed on behalf of NCPCR, but we had to take lots of inputs from the Ministry of Women and Child Development and also CARA. So Lordship may take it that these submissions are, my lords, comprehensively from these 3 bodies, my lords.
Which submissions you will be referring?
My lords, we filed our submit. I made
Yes,
a brief.
we have your list of.
Lordships
you
have
a
my
written
submissions, my lords. It is in 3 parts, my lords. Part A, Part B, and Part C. I can actually confine only to Part B because other aspects are which are covered, but that's just for the sake of completion, my lords. It's a short note. And there are 3 compilations, my lords, A, B, C, and 1 filed yesterday, D.
So we have now a master index by Ms. Bhati.
Please, my lords.
Then we have Part A compilation, Part B compilation, Part C, and Part D compilation.
Please,
then
my
your
lords.
written submissions.
Please, my lords.
That's the.
Lordships, please. My lords, Part A of my note is, my lords, where I'll just give a brief. Wherever your lordships want me to stop and elaborate, I will.
Yes.
I'll just give an outline, my lords. So the first Part A really deals with 2 submissions, my lords. First, I have tried to submit that there's a basic structure of the marriage, and that is a union of man and woman. The second submission I have, my lords, is gender fluidity. I'm not elaborating, my lords. I'm just stating my propositions. And the second submission I have is that gender fluidity is impermissible where cisgender is core. And ignoring rationale of valid classification amounts to perpetuating inequality. Then I've given examples of areas which have been reserved specifically for women. Because if these spaces are diluted in any manner, then what will be lost is really the cause of women's equality, women's well-being, women's empowerment. That is my second point, my lords. And I've given examples like women's recruitments, spaces which are specifically for women, women's washrooms, women's correctional homes, women inmates, welfare homes, ladies' bar room in the Supreme Court. When your lordships recognized in NALSA transgenders as a third gender, your lordships did not, using the expression that Mr. Datar did, my lords, did not retrofit in the 2 existing genders. Your lordships identified them as a third gender. So, my lords, it's very critical that gender fluidity cannot be permitted in areas where cisgender is core. That brings me, my lords, now to Part B. That is specifically with regard to children. And my lords, the preposition that I have is welfare of child is paramount and sacrosanct and cannot be opened, exposed even for an iota of potential compromise or uncertainty. My lords, for the first preposition, that is the child has a right to be born and raised by biological parents. My lords, for this I will rely on note 2 of the learned Solicitor General for India, my lords. Your lordships will kindly have page 39 to 49 of that note. There are some research papers also which is there in their compilation, but learned SG's note quotes the paragraphs that are relevant. If your lordships will kindly take that with me, my lords, page 39 of note 2 of learned SG. Only for the purpose of these 2 prepositions, that the legitimate state interest of ideal mode of child rearing. My lords, all children are naturally born only to heterosexual couples. And now, my lords, when I take your lordships through the architecture of my lords laws which are relating to children, there are no competing rights in this space, my lords. The only sacrosanct paramount right is that of the child. To the extent that sometimes a child may need to be protected from himself. The entire, my lords, architecture of these laws are from the concept of welfare of child being paramount. So, my lords, my respectful submission is, if your lordships will, my lords, have page 39 of learned SG's note, my lords.
Which note?
Note 2, my lords.
Note 2.
Note 2 of the learned SG. This chapter, my lords, the
Violation 2. Note 2.
Note 2. PDF page 39.
my lords, it's running 39. PDF should be
PDF of 44.
44. It could be, my lords. 42. I'm grateful. 42, my lords.
42.
The legitimate state interest of ideal mode of child rearing. Am I,
Yes.
my lords?
Page 42 starts with Note 2, Fundamental Rights, para 59.
My lords, this is para 63.
63. Very well.
Bottom.
Got it.
Yes.
My lords will see, my lords, this is for the preposition that legitimate state interest of ideal mode of child rearing. Now, lordships will, my lords, the fundamental point is that a child can only be naturally born through a heterosexual couple. And therefore, the special significance of recognition of heterosexual marriages cannot be understated from the point of view of child, birth of child and bringing up of the child, both. My lords, there are some very interesting papers that have been put together, my lords, in the research of this note. And my lords, these papers show that fathers and mothers both play complementary roles in upbringing of the child. And state is justified in treating homosexual and heterosexual unions differently for that purpose. The first paper, my lords, that is quoted in para 66 is straight is better while law and society may legitimately prefer heterosexuality is a paper, my lords, from a professor of law, my lords, of Case Western University, Ohio. Your lordships will find that at page 353. The entire paper is there in compilation, volume 8 of Learned SG, my lords. It's mentioned here. The relevant paras are quoted here. And if I can draw your lordships to the last para that is quoted at the next page, my lords.
Which page?
Marriage, my lords, I am at page 41, the noted page 41.
Yes, but which compilation?
Same thing.
Note 2.
Same thing.
OS.
Learned SG's note, my lords. I was just giving that the complete paper is there, but the relevant portions are here. So, marriage is not a factory for childbearing. Marriage exists to encourage men and women to create the next generation in the right contexts, and simultaneously to discourage the creation of children in other contexts out of wedlock in fatherless homes. Well, that's the next paper that's in para 68 is marriage from a child's perspective. How does family structure affect children and what we can do about it? Please see the highlighted portion. It is not simply the presence of two parents, as some have assumed, but the presence of two biological parents that seem to support child development. Children in single-parent families, children born to unmarried mothers, children in step families or cohabiting relationships face higher risk of poor outcomes than do children in intact families headed by two biological parents. Parental divorce is also linked to a range of poorer academic and behavioral outcomes. The next paper, my lords, this is my lords, Pennsylvania University law professor. The next paper is Tradition, Pluralism and Same-Sex Marriages. This has 4 authors, my lords. The paper your lordships will find in volume 8 of the Learned SG's compilation. Please see, my lords, the highlighted portions in the second para. To date, the research on child well-being and family form bears out that children thrive on structure, order, routine, stability, continuity, certainty, and clarity. The evidence shows that conventional beats unconventional every time. This means that complexities and ambiguities of non-traditional families come at a price.
But Ms. Bhati, our law permits a single person to adopt a child.
My lords, permit me to come to that now.
Yes.
Your lordships will see this, my lords. The Learned SG did not place it. Lordship may note that this is, my lords, from page 39 to 49 on both the prepositions. The first is, my lords, that the legitimate straight interest, and that I showed to your lordships, and that there are some papers, my lords, on there is lack of data to establish equivalence with biological heterogeneous upbringing of children. Lordship may see it. I just brought it to your lordship's notice because it was the Learned SG left it to me, my lords.
Right.
Now, please come back to my note, my lords. Your lordships will see
Which is your note now?
My lords, your lordships had my note, welfare of child.
One second, yes.
I'm sorry, this
To go back.
I've
written
opened so
submissions
many.
on behalf of,
Yeah.
so I've said only NCPCR, but it's also the ministry and CARA.
Written
My lords will have para 8, my lords, at internal page 5, at page 5 of my submissions. This I have placed. The second proposition is,
I
Just
don't
a
know which
moment,
page,
just
sorry.
when Ms. Bhati, we are
I'm
still
sorry, my
looking.
lords. Yes, my lords.
Right.
Para
This is
8.
para 5 at page 4.
No, but which note is?
This is the Ms.
Note,
Bhatti's
you're
note.
talking of note
There's
two,
only
you
one
said.
note. Written
Yes,
sub-
my lords. Yes, my lords.
Gender fluidity, right?
Yes, my lords.
This-
That I just mentioned, and then I came to part B, which is at
Aishwarya
page
Bhati.
5. I hope my lords justice call have my lords the
Yes, I have it. That welfare of children is paramount and
very
sacrosanct.
grateful, my lords.
Click on Aishwarya Bhati and you'll get.
Eight. My lords, I only touched the prepositions in part A because it has been extensively dealt with, and I am at my lords para 10 now, my lords.
Para 10.
State as parents patriae of children, my lords. And this is critical, my lords. I will show to your lordships the Juvenile Justice Act, because the entire architecture, when it comes to the legislations with regard to welfare of child, my lords, it's the child alone who has rights. And my lords, it's in sync with the UN Child Right Convention. It is in sync with the constitutional philosophy and ethos. And please see how the Juvenile Justice Act deals with. May I request your lordships to take my compilation A. I put the acts there so I can show.
Why don't we go through your written
sub-
note? That might be much better so that, we can get
Then your
a
lordship will
structure in our mind.
Wherever necessary, we will go there.
So, my lords, I'm not touching this aspect of parents patria any more than mentioning it that it's the
Absolutely.
settled.
Very well settled, so you don't have to
I
read out the
put
case
some
law.
paras from your lordship's judgment. Then your lordships will see para 11, my lords. The architecture of child legislations is so pervasive and significant that it even extends to covering beneficially the mother of the child. My lords, human child, my lords, I don't have to state it, but human child really is one of the most helpless childs of all, my lords, living beings in the nature. And it needs all pervasive, intense and indulgent care in the early years. And therefore, my lords, mother has been strongly protected, not just in the Constitution, but also in the Juvenile Justice Act, the Maternity Benefit Act.
Yes.
My lords, Article 42, I have, my lords, adverted to in para 11. And my lords, para 12, I have stated that a gender may be fluid, but the idea of mother cannot be. And therefore, my lords, it is very pertinent and important that this is given a very careful consideration. The whole perspective is, my lords, that what I'm presenting for your lordship's kind consideration is from the point of view to show to your lordships that this architecture, how it is going to be, my lords, impacted by a declaration and reading into Special Marriage Act.
Against the situation, which is, forget about the gender part. There's sometimes only a father who has
We
to
have
care
gone
for
beyond
the
motherhood. We have gone into parenthood today.
Yes, my lord.
Because there are, as Justice Kohli is mentioning,
Please, my lord.
there are single
parent,
parents.
Please, my lord.
Now,
male or a
there
female.
is a death at childbirth.
Please, my lord.
The mother unfortunately dies of disease or accident.
Please, my
The
lord.
compulsion.
And there is no question of the caregiver being the father,
Please, ma'am.
regardless of. Likewise, there are adopted children
Children,
Yes,
of
ma'am.
only, of males,
Please,
by
ma'am.
men, by fathers. So it's gone beyond the concept of, in that sense,
I bow down.
in that sense, when the Constitution envisioned it, and some of this parents patria, interestingly, if you see the quotation of Lord Justice Lindley, he talked about husbands, guardians, and fathers.
Please, my lords.
So that was a situation where women didn't have agency. Women were even seen as wards.
Please, my lord.
Right? So therefore, the question of guardianship was that with men.
Please, my lords.
So it's an evolving,
I bow down, my lords. I bow down to what is falling from
what
your
is
lordships.
central to this, yes, is unchanging, which is the welfare of the child.
Please, my lords. So, my lords, my respectful submission would be, my lords, that your lordships may see it from the perspective that this method of naturally born heterosexual couples bringing up their children is the ideal mode. And the law and the entire regulation has provided for, my lords, children who do not have that. From that perspective, please see now, my lords, the aspect of adoption. I have given one example in para 13 of sponsorship, which is available to only widowed, divorced, or abandoned mothers to seek sponsorship for their children. That's a protection under Section 45, specifically available only to this category of women, my lords. Then please see, my lords, please see para 14. My respectful submission is adoption is not an alternate to biological birth, my lords. My respectful submission is that adoption is a mechanism to find
Equally,
best
our law does
possible-
recognize that you can adopt for a variety of reasons.
Yes.
You may adopt even though you are capable of biological birth.
Please, my lords.
You can adopt if you don't want biological birth.
Please, my lords.
There's no compulsion to have biological children. Therefore, our law does recognize
Please, my lords.
the fact that there may be situations within this ideal of, a cohabiting family with, father and mother of, of a heterosexual gender family having their own biologically born children. But that's not
Please.
how our law is postulated also, right? What happens if, suppose, between the pendency, during the tenure of a heterosexual marriage, one of the spouses dies, then the other spouse really assumes the character of a father and the mother, depending on, isn't it? So that is something which our law recognizes.
My lords, I bow down. The law recognizes again from the perspective of the child. Your lordships have held that there is no fundamental right of adoption.
No, I think we may differ on that, because even if you go back to tradition,
Yes, my lords.
the right of a grandfather to take in adoption
Please, my lords.
the son of the daughter, what is classically known as one of the approved forms of having a child,
Yes, my lords.
Pitrika Putra.
Please, my lords.
So that is a known notion. So it is not that this is no sanction. It is hallowed. It's hallowed in
My lords,
tradition.
I bow down, my lords.
Therefore, to say this is an exception may not be appropriate.
My
That
lords-
why did even in some schools, even grown women, widows are enabled to adopt? Why? There's another purpose there.
My lords,
And even there are situations where adoptions take place, and thereafter there is biological birth.
please.
That too happens. So
My
there are
lords.
any number of situations where adoptions is the norm.
My
But
lords.
yes, you're right that, but then all this is serving to emphasize and heavily underline that there is a normal and these are exceptions.
My lords, my respectful submission is not of exception. My endeavor is to present to your lordships that all of this is crafted together from the perspective of child being at the core of it. It's
There's no
not
difference.
right that in yours.
Ms. Bhati, that you need not labor at all. That
May not be, that may not be.
But the welfare of the child is paramount, obviously.
Definitely.
True, true.
So, my lords, adoption is, I want to show to your
But
lordships.
the means of realizing that welfare are numerous. The pathways are
I bow down.
numerous.
I bow down. In fact,
Some of
adoption.
them are a matter of choice, some a matter of compulsion.
Function.
I bow down, my lords, and the CARA guidelines
But
actually.
tell us one thing, is it your case that a right which is otherwise available to an individual to adopt a child is taken away because that individual is in any relationship otherwise than a heterosexual marriage?
That is right, my lords. And that is not just true for adoption. That is true for assisted reproduction, which is now regulated by the assisted
So
reproduction.
if two people are in a live-in relationship,
Yes, my lords.
Does that mean that therefore, because of the fact that the two people are in a live-in relationship,
Yes.
maybe a heterosexual couple, that they will not have a right to adopt?
Not under the existing law, my lords. Not just adopt,
But
my lords.
is the right of one of them to adopt taken away because she or he is in a live-in relationship?
My lords, one of them can adopt. But the only couple relationship that adoption
It's a heterosexual
and
living.
surrogate reproduction, all three of them only recognize one kind of couple. That is a heterosexual married couple.
Therefore, no. But therefore, if two people, if a
Yes.
heterosexual couple is in a live-in relationship, one of them can certainly adopt. Or is it CARA's case that we will deny you the right to adopt because you are in a heterosexual live-in relationship?
No, my lords. I permit me to show it to your lordships the CARA
If I
record.
may paraphrase your argument, it is
Yes, my
like
lord.
this. The public policy consideration which you are actually mooting or advocating, or rather stating, is that yes, we allow adoptions by single, let's say, males, single females, in their capacity as single males or single females.
Please, my lords.
But
not
the
if they're
moment
in a
they enter into
relationship.
either a
Union or
same-sex relationship or another kind of live-in relationship, that relationship is not per se recognized.
I bow down, my lords.
So the only recognition of a relationship of father and mother is where there is a
Heterosexual marriage.
Lordships, please. And that is true not just for adoption, but also ART Act.
My question is different. If people are in a live-in relationship,
Please, my lords.
then is the right of an individual in a live-in relationship to adopt taken away by virtue of the fact that they're in a live-in relationship?
My lords, they will not be, so only one parent can adopt as a
Fair
single
enough.
mother or the single
That we've got.
lordship.
But your circular says something to the contrary.
No,
Because your circular says that the moment you are in a live-in relationship, albeit in a same-sex relationship, then you cannot adopt even as a single individual.
my lords, I will quickly take your lordships through the architecture of the JJ Act.
Also,
Yes,
keep in
sure.
mind one more fact, Ms. Bhati. Besides the fact that Honorable the CJ has pointed out.
Please, my lords.
There is that condition. And what if, and that what if will be important, that somebody per se says that he or she is not in a live-in relationship, you probably have a format or something that a person has to sign or say this for you to satisfy yourself, and subsequently does, then what happens? Will the child be taken back?
My lords, there is provision for disruption and dissolution in adoption also. There, my lords, it is carefully crafted because child who is adopted will become a child of that person for all purposes, for inheritance,
That's right.
for all other rights. So, my lords, it cannot allow this. There can be no uncertainty in, my lords, in these matters when it concerns.
Person, if he or she elect to adopt, will for the rest of their lives have to undertake that they will never be in a
No,
relationship.
my lords, there is no undertaking like that.
Unless it's a case of
No,
them
my lords.
actually marrying.
No,
What
my
is
lords,
it
there-
that you are put?
There is no
What
undertaking
is
like.
it that you are?
My lords, what I will tell your lordships how they are constructed is that a heterosexual married couple has to also have 2 years of stable relationship of marriage before they can adopt. It's not like they can, and they have to have consent from each other.
And if
It-
it's a single parent,
If it's a single parent, then there are other considerations. What is their age? What is the gender of the child? What is their gender? I want to quickly show to your lordships the architecture under the JJ Act, the CARA.
Show us that.
Lordships, my lords, that compilation A, I have put all the 3 acts.
Sorry.
My lords.
all
Mr. Bhatti, what I can get what sister is saying is, suppose there is a single adoption.
Please, my lord.
There is an adoption by a single person. After a couple of years, child is being brought up by that parent and he decides, you can't guarantee the future what will happen. So he decides to have to begin with a live-in relationship. That's not a disqualification.
Not at all.
It will be there. So how do you explain this?
My lords, I will quickly take 5-10 minutes and take your lordships through the architecture, starting with the
Ms.
JJ Act.
Bhati, we can recognize 2 points which you have made. One, if a couple wants to adopt a child, then our adoption regulatory regime only recognizes the right to adopt when you are in a heterosexual marital relationship.
Please, my lords.
All right? That's your first point.
Please.
We understand why and what the public policy underlying that is. That if you have to be a couple, if you have to be a mother and father, you must be necessarily in a heterosexual marriage before you can both adopt a child as a couple.
Please.
That's your first proposition.
Lordships.
What we are asking you really is on something slightly different, which is nonetheless, our law recognizes the right of a single individual to adopt.
Yes, my lord.
And the question, therefore, is, and we take it that's your position also, that the right of a single individual to adopt is not affected by the relationship which that single individual may otherwise have, whether it's in the nature of a live-in relationship, which is heterosexual, or a live-in or a relationship of a same sex, so long as you are adopting, as a single individual.
Lordships, I bow down, my lords. That is my stated position. And my lords, your lordships will appreciate that because the law.
So we therefore take it that even a same-sex couple,
Yes, my lord.
or let me rephrase it, an individual in a same-sex relationship
Please, my lords.
is not precluded from adopting a child. We
Please,
take
my
that as CARA's statement of position.
Yes, that is the mandate of Juvenile Justice Act.
Jeez.
That is the mandate of.
If I may just make one more statement,
Lordship.
you will agree with. A single parent
Please, my lord.
who adopts remains a single parent, there is no difficulty. The moment she enters into a matrimonial relationship
Please, my lords.
with, it's a heterosexual relationship,
Please, my lords.
then the husband becomes the father,
Lordships.
correct? The adoptive father, like she's the
Lordship.
adoptive mother. So then the child, as a consequence, becomes the heir in the event of death to the properties of either,
Yes, my
and
lords.
rather both.
Yes.
On the other hand, if the single parent enters into a same-sex relationship, then the adoptive child continues to be the adoptive child of that adoptive father or the mother.
Please,
And no more, full stop.
Yes.
This is your proposition.
Lordships. My
What
lords.
you say is.
So
that,
therefore,
it doesn't
sorry,
recognize-
just to take one thought further, what you're driving at here is the stability. Because even in the event of disruption of the family, like in the case of marriage, there is a divorce, the relationship of an adoptive child continues.
Lordships.
Whereas since there is no marriage and there is no marriage recognition, that stability would be undermined if you recognize.
I bow down, my lords. I bow down to your lordships. My lords, Justice Narasimha had a point.
Same. I was
My lords, in
looking
fact,
at
CARA has
your argument.
a fast track method for step parent adoption also. It may happen that somebody has a natural born child and she becomes a divorcee or a widow and she remarries. So her child can be adopted.
Yes, by
There's a mechanism that is.
Obviously, yes.
My lords, it's actually very carefully crafted. My lords, we are a culture of my lords,
Perhaps-
Yashoda Mata and also Devki Mata, my lords. So
Perhaps-
both, my lords, one who gave birth and one who reared the child.
We will see those regulations. Perhaps there might not be anything formulated to say it's prohibited. But while hetero marriage might be recognized, same sex, the rules might not have provided any recognition. We will have a look at those rules.
Actually, my lords, that is why live-in is also not recognized, because live-in also is what Mr. Sybil was mentioning yesterday, the within, the concentric circles. The without is not recognized for live-in. Live-in are, my lords, now recognized under the Domestic Violence Act,
So a
120.
living couple cannot adopt a child as a couple.
Yes, because they can walk out
That's
of
fair
the
enough.
relationship anytime.
Fair enough. Then we understand what the public policy precept underlying it is.
Please, my lords.
But the existence of a live-in relationship does not prohibit one of the parties from seeking to adopt a child
Yes, my lords.
as an individual.
Yes, my lords.
So you're looking at it from the perspective of the child, which is that the
Lordships.
child is most benefited in every formation. At least there is one person responsible for that.
I bow down.
That stability is what you're actually driving at. And the
Lord-
core,
And the fact that one individual has adopted, that right to adopt or the continuance of that adoption is not affected by any subsequent change in the marital status of that individual who was adopted.
Please, my lords. Please, my lords. My lords, in fact, the ART and Surrogacy Act, the validity of some provisions are being considered by Court 5. There are a clutch of petitions that have challenged some provisions. And my lords, there was a point that was sent to the National Board for reconsideration. There's a very, my lords, well-equipped national board under ART and Surrogacy, because they are also, my lords, in a manner only recognizing this couple of heterosexual married couple as a relationship. And my lords, single women are allowed under the ART. And only widow and divorced women are allowed under
Then, Ms.
surrogacy.
Bhati, can we then summarize your submission in the following terms? That just as there is no recognition, according to you today, in the state of our law, of a same-sex marital relationship, which is legislatively recognized. Parallelly, there is no recognition in our law today of the right of a same-sex couple to adopt a child as a couple.
Lordships. Yes, my lords. I bow down, my lords.
And that is based on the foundation that a child must have a stable family existence, and which you postulate would exist in the case of a heterosexual marriage.
My lords, would your lordships just make a note of the sections that I am, my lord,
Yes.
giving to your lordships? The Juvenile Justice Act, my lords, I wanted to show to your lordships, it is at page 82 of my compilation A. I wanted to show chapter 8 to your lordships. And before that, I wanted to show some definitions and some general principles which are in section 2 and section 3. My lords, those general principles are very, very critical, my lords, from my perspective, because that is really an
Provisions you want us to see?
My lords, I want to draw your lordship's attention to some definitions in section 2 and general principles in section 3, my lords.
Which are the definitions section 2?
My lords, the definition sections, there are 3 kinds of children who are available, my lords, free for adoption. My lords, abandoned child, orphan child, or surrendered child. My lords, this is
It's 82, volume compilation 1, I think.
compilation A, my lords, we are calling it, and lordships will find it.
Printed 87, actually.
Yes, my lords.
Printed
Page 82,
87.
it starts, my lords.
Printed 87.
Compilation, which compilation is it? She said?
Compilation A, my lords.
Yeah, no? In a
Yeah. All right.
Also, 87, yeah.
Printed 87.
You have
It's
87.
index and 87 it starts, my lords.
87.
Yes.
So these 3 definitions, your lordships will note, my lords, abandoned child to 1. Then, my lords, please see a definition of adoption itself. Process through which adopted child is permanently separated from biological parents and becomes lawful child of adoptive parents with all rights, privileges, and responsibilities that are attached to a biological child. Best interest of the child means the basis for any decision taken regarding child to ensure fulfillment of his basic rights, needs, identity, social well-being, physical, emotional, intellectual development. Child means anyone below 18. Please see 15, child-friendly, 16, child legally free for adoption. Please now come down, my lords, to orphan at 42. Section 2, subsection 42, orphan. Then, my lords, 49, prospective adoptive parents, same as 57. Now permit me to, my lords, take your lordship. A surrendered lordship will note is 60. Section 2, subsection 60 is surrendered child. And sponsorship, an example of which I gave, my lords, is defined at 58. My lords, the general principles, my lords, that are in section 3, there are total 16 principles, my lords. My lords, they've been culled out from the United Nations Child Rights Convention. And my lords, I want to highlight to your lordships the aspect of number 1, presumption of innocence. My lords, the principle of best interest to develop full potential, principle of family responsibility, positive measures, my lords, and I want to read this one, my lords. All resources are mobilized, including those of family and community, for promoting well-being, facilitating development of identity, providing an inclusive and enabling environment to reduce vulnerabilities in children and the need for intervention under this act. This act is not to promote adoption. This act is to make sure that there are less and less interventions under this act.
You are reading from section 3?
Section 3, principle 6, I placed.
6th one, okay.
That's positive measures.
Fingers. 3:35. Started.
My lords, your lordships will appreciate. Just reminding your lordships of X versus Union of India, my lords, judgment that my colleagues have relied on. In fact, we were fortunate that your lordships gave us the privilege to assist your lordships in that. Medical termination of pregnancy is the border in our respectful submission where the individual rights end. When it comes to, my lords, child that's already born or unborn in the case of ART and surrogacy, it's the welfare of child that alone is the underlying basic principle, my lords. So the parameters will be completely different. My lords, in Navtej, in X, in Nalsa, your lordships were dealing with competing rights. Marriage as an institution, with procreation being such a fundamental core to it. If your lordships read spouse in the Special Marriage Act, my lords, it is going to have impact, my lords, that polycentric spider webs, my lords.
That has been already argued.
It's going to impact the children laws the most in ways that we can't even fathom today. Because children need that certainty of law, that conformity, my lords. And the only reason why any other relationship, though there are other kinds of relationships which are recognized in other laws, go to, my lords, great lengths to protect their children from when they can vote, when they can marry, when they can drink, when they can. And, my lords, the right of repudiation, the right of non-waiver of rights. These are the principles on which they have all been founded. The right to a fresh start, the POXO Act, the entire architecture, consent is immaterial. An independent thought, your lordship said, even a minor spouse would be covered. The entire, my lords, architecture of your lordship's judgments and the statutes has been from the prism of the child and none other. My lords, it's not in my compilation, but there is, my lords, some lines from Justice Bhagwati, my lords, in the judgment of Lakshmikant Pandey versus Union of India. This is 1984, 2 SCC 244. Just want to read two lines to your lordships, my lords. This is the judgment where your lordships were dealing with the problems of inter-country adoption and the entire infrastructure, the entire regime of Juvenile Justice Act and CARA came by virtue of your lordships nudge and push in this judgment, my lords. Para 6, just two lines I want to read to your lordships, my lords.
Then aren't you Aren't you serving the petitioner's cause by pointing to this vacuum and what this court did?
My lords, my respectful submission is your lordship may go the slowest when it comes to rights of child.
Yes.
My lords, para 6, just 2 lines, my lords. My lords, I'm sorry, my lords, I'll just read. They're just 2 lines, my lord. Justice Call may kindly bear with me, my lords. This is 1984 to SCC 244, para 6, just 2 lines, my lords. It is obvious that in a civilized society, the importance of child welfare cannot be overemphasized because the welfare of entire community, its growth and development depends on the health and well-being of children. Children are a supremely important national asset, and the future well-being of the nation depends on how its children grow and develop. The great poet Milton put it admirably, and he said, "Child shows the man as morning shows the day." And study team of social welfare said much to the same effect when it said physical and mental health of a nation is determined largely by the manner in which it is shaped in the early stages. Just that much.
This is well taken, but you must show children in the context of same sex.
My lords, my respectful submission is from the perspective to show to your lordships that this architecture is carefully crafted, my lords. My lords, here, heterosexual couples also don't have rights that equate to them. My lords, there are categories within categories created. Man and woman don't have same rights. A single man and a single woman do not have same rights. So from that perspective, my lords, there is no, in fact, the only recognition is to the child's right. In fact, when I'll show to your lordships, my lords, your lordship saw that section 3, my lords, with me. My lords, then please come to straight away chapter 8 of the Juvenile Justice Act, my lords.
Since we've given you 30 minutes, we are already now 45.
I'm sorry.
So no, not at all. You made a very valid point, and you never, yeah, everything that you say is always very precise and full of substance. So just formulate your submission so that, forget the submissions, we'll read the submissions, of course. But if you can just formulate it, so that then we can take it down and then we can focus on it.
Lordships may go through only my note. Just part B is the portion that I've dealt with. I'm just going to quickly tell your lordship.
If you can just sort of highlight what are the key areas, because I think now we've seen the broad architecture, etc., of the law that you have showed us. You can formulate 3 or 4 key submissions, and then we can.
My lords may note, my lords, in the CARA adoption guidelines, the latest ones are of 23rd of September 22. That's at page 228, my lords, in this compilation A. And
just 1 second. Let's just take it 1 second.
228, my lords.
3rd of September.
My lords, this is 23rd September 22. These are the latest guidelines, but I put the old guidelines of 2017 also, and there are very little changes. The architecture continues in the same manner.
Ms. Bhati, what page?
My lords, this is page 228 in compilation A.
Compilation A.
And my lords, your lordships will pay close attention, my lords, is my respectful submission to the general principles governing adoption, regulation 3, regulation 4, child eligible for adoption. My lords, this OM that came was from steering committee, my lords, discussions. One point that was put was that child is trans. How is he dealt with in CARA guidelines? CARA guidelines make no distinction. What is the gender of the child? What is the disability of the child, if any? What is the age? Well, so protection is given only on 2 occasions. What is the age on which it is given? So lordship will have a quick look at regulation 5. That gives, my lords, regulation 4 gives child who's fit for adoption, and regulation 5 gives eligibility for adoptive parents. That's at page 230, my lords. Your lordships will see that man-woman relationships are immaterial. So a man cannot adopt a young girl child. And it is in this manner, my lords, that it has been crafted. Then 2 years of stable married relationship is extremely critical. My lords, that your lordships will find in regulation 5. My lords, I also want to draw your lordship's attention to, my lords, seniority in regulation 44 and root search in regulation 47. My lords, seniority, your lordships will find.
Sorry, regulation 44 and?
Regulation 44 deals with seniority of prospective adoptive parents.
And
my lords, regulation 47 deals with root search. So every child is entitled to a root search, adopted child also. when either if he becomes a major, he's entitled to do that on his own or through his adoptive parents. And my lords, in the entire architecture, only at one place the biological parents' rights is protected. That is Regulation 47, Subregulation 6, where it says that the right of an adopted child shall not infringe the right of privacy of biological parents. This is the only place. So if biological parents wish their privacy to be protected, then this root search will not be given. My lords, I've given in yesterday's compilation a flow chart of how adoptions happen, my lords. My lords, I've given a data also. In fact, I took from CARA data. Lordships will find that at page 1 of my yesterday's compilation. Roughly, my lords, I've given gender-wise. How many boys, how many girls for the last 8-9 years? How many have been given up in adoption? How many parents have registered? So roughly, to give your lordships an idea, there are about 30,000 parents who are registered prospective adoptive parents waiting for adoption. And the children, my lords, here who are in the pool are less than 1,500. There is a mechanism for, my lords, you have to reserve every prospective, and then, my lords, there is a mechanism for intra-country is the last resort.
Only 1,500 children are available for adoption across India?
My lords, yes. And not yet available. They are in the pool. My lords, because there is a time period that's available for children who are surrendered. The biological mothers or parents can reconsider if they want to. So there is a mechanism that is laid down, my lords. And then they are put in the, my lords, I've given a flow chart also of how adoption happens. It is only through Caring's portal. No interference by humans. It is a portal that is automated, my lords, completely. The option goes to the next in seniority as a prospective adoptive parents. They are given 48 hours. They have to give their ethnic background, their choice, gender choice. My lords, the home study form that's a schedule in this, my lords, in these regulations is so exhaustive. You have to disclose not just your health conditions, income, your parents, your other family members, your children. My lords, it is so comprehensive that because it's important. Where the child is, because there is a process of matching that has to happen. After the parent decides that this child might be fit, there is a matching that has to happen, and it's only after that matching that the child is, my lords, given.
Just a question out of curiosity. We appreciate how much effort has gone into ensuring that the child is safeguarded in every which way when he or she goes to a home. What is the timeline ordinarily for an application once a party applies, a parent to be applies, and it matures by actually handing over the child to that adoptive parent?
I've given that in my
Do we have data?
But 3 years.
Do we have data of neglected children who are in care institutions and who are not, of course, not adopted? Do after turning 18 go? I mean, I won't use the word they are turned away, because care institutions don't cater to any adult.
Yes,
At the age of 18, if the child is not adopted or not cared for, in the sense that there is nobody to sponsor her or him, and he becomes an adult.
Yes, ma'am.
What is the future of that young adult who was a child till then? We have, I mean, there is no data. Actually, there is no data. And if you say 30,000 applicants are
Prospective parents.
of prospective parents, then 1,500 only are available.
Yes.
Isn't it a matter for concern that we look into every care institution? And there are thousands. We have, at least in Delhi itself, more than 50.
My lords,
And Tamil Nadu, we have, I think, 250 or so.
My lords, this is the data of, well, if your lordships will see page 2 of my yesterday's compilation of legally free children available as on 28th of April 2023. The CARA guidelines prescribe a procedure in which the child has to be declared free for adoption. My lords, it's a very razor thin edge walk, my lords. The child is being separated from biological parents, surrendered parents, or orphan, my lords. Orphan also, my lords, there is a provision for family adoption, because, my lords, our culture, we are polycentric even in families. There will be nani, dadi, masi, mama, buas, whole lot, my lords, and they have right of, my lords, accelerated rights of adoption for family members. So there is the whole process. If the process is not followed for declaring the child legally free first, before giving up in adoption, it is going to I just want to quickly, my lords, just tell your lordships what the rest of my note is. Lordships will just see that, my lords, I have also, my lords, I've adverted to in between the ART and the surrogacy mechanism is also like that. I just quickly want to mention this, my lords, the National Board of Surrogacy and ART, they were referred some, my lords, issues that why are you not allowing donor gametes in a surrogacy? My lords, the answer very clearly that has come from them is emotional bond of the child is very important. We can't even take 1% chance. So they say between the egg, the sperm, and the uterus, at least 2 of them have to be of biological parents. So while ART allows donors, surrogacy, where you're using the uterus or womb of another woman, altruistic, no commercial, because now the regulation is very clear. You can't use donors. Though Malad's Code 5 will deal with those challenges, but the reasoning that has come is that there has to be a strong emotional bond of the parents who are going for these assisted mechanisms. Malads, we have given, I think I've covered most of it, Malads. I would draw your lordship's attention to, Malads, one more aspect. The special provisions with regard to children, to women, my lords, is also something that your lordships will have to look at very carefully. We have made a compilation of, my lords, laws where women are protected by virtue of their married or domestic relationships.
Thank you, Ms. Bhati.
And my lords, one more thing, we made a chart of these 34 countries which have in some manner recognized their civil unions, though it's a phenomena only of this millennium, my lords. But they have recognized, we made a chart, my lords, we've given a source of that also. 27 of them have gender neutral rape laws. Social fabric is different, my lords. That chart your lordships will find, my lords, in our compilation C at page 1492. The source is also there, my lords. 27 countries gender neutral, 4 are gendered, 3 we could not confirm because they were in languages, my lords, though we tried AI of the internet to get the sources. My lords, I'm very grateful to your lordships. I had, my lords, just written an opening line. If your lordships will permit, I'll read it, my lords, at my closing. The entire endeavor of ours is to present to your lordships that the architecture of child-centric or child welfare laws is very carefully crafted with welfare of child being paramount. Any general declaration reading in spouse instead of husband and wife will make laws relating to adoption, assisted reproduction, surrogate reproduction completely unworkable. Even for the legislature, my lords, which has the tools of wide consultation, expert and specialist advice, my lords, options of calibrated and gradual solutions, opportunities of amendment, savings and repeal. That, to my mind, is a very, very important tool, my lords, the option of adoption, savings and repeal. My lords, they will also find it very onerous responsibility to balance on one hand the competing rights and on the one hand protecting the parents' patria responsibility of the welfare of the child, because that is non-negotiable.
All right. Thank you, Ms. Bhati. Thank you.
I am very grateful, my lords.